What's going on, everybody? Welcome to my YouTube channel, and today we're going to be talking about the prospect of constitutional carry in my home state of Indiana. Stick by and let's get this going. What is going on, everybody? I am super excited for this video today because today we're going to be talking about an Indiana Supreme Court case that would make having to carry one of these a thing of the past. Penner v. State, Indiana Supreme Court case that dealt specifically with carrying guns in Indiana. Long story short, guy by the name of Penner walks into a movie theater in Indianapolis, stopped and detained by the police because he had a gun on him. Police want to know if he was a criminal or if he was allowed to have that gun, and conducted a search to figure out that he was in fact a criminal, wasn't supposed to have the gun in the first place, he was a felon, but because of the way they went about getting that information, it was all irrelevant, fruit of the poisonous tree, couldn't be used against him in the court of law, and today we're going to talk about that court case. Essentially, they decided that just like in Delaware v. Prowse, which is a United States Supreme Court case dealing with stopping motor vehicles at random to check to see if they had driver's licenses, in the same fashion, the Indiana Supreme Court case has ruled that you cannot stop a person just to see if they have a valid permit to carry a handgun. In this case, we're going to go over the facts of that and see how they got to that determination, but long story short, it's a major violation of the Fourth Amendment per the justices on the Indiana Supreme Court to stop and detain an individual if they see them carrying a gun just to see if they have one of these. So without further ado, guys, let's go ahead and jump into the information and enjoy the video. Alright, everybody, so Penner v. State. This is the court case that was decided in the Supreme Court of Indiana on May 9th, 2017, for anybody who's wondering. Obviously, the link to this actual court case will be in the description box below for all of you who choose to follow along or do a little bit of your own research on your own time, which I would always highly recommend. So the most important part of this court case, in my opinion, is that they don't actually focus on the Second Amendment at all. What they do is they focus the entire court case on the Fourth Amendment, your right to protections against unreasonable searches and seizures. They start by saying that the Fourth Amendment to the United States Constitution guarantees the right of the people to be secure in their persons against unreasonable search and seizure. And then they go on further to say that generally, to be reasonable, a search must be conducted pursuant to a properly issued warrant supported by probable cause. Then they go on to say that, however, police may, without a warrant, stop an individual for investigatory purposes if, based upon specific articulable facts, the officer has reasonable suspicion that criminal activity may be afoot. And they reference the court case Terry v. Ohio here to get to that conclusion. However, the crux of this case is that Penner contends that the officer lacked reasonable suspicion that he was committing or about to commit a crime to justify an investigatory stop. Specifically, he alleges that the tip from the cab driver did not provide the officers with information sufficient to determine he was engaged or was about to be engaged in criminal activity. So here, in the very beginning of the court case, they're saying that the police stopped Penner because they got an anonymous tip that he was carrying a gun. But according to Penner and his counsel, the police were actually unable to stop him because even in Terry v. Ohio, where you have to have reasonable suspicion, articulable reasonable suspicion that criminal activity may be afoot, that the police actually lacked that just based on the tip provided by the cab driver. The state then, in this court case, says that, the initial encounter with Penner didn't implicate Fourth Amendment precautions because it started off as a casual encounter, and they referenced United States Mendenhall for that one. This is the Supreme Court case that deals all with the difference between casual encounters between police officers and when and where and how encounters turn from casual encounters to actual detentions. And so in the beginning, the police for Indianapolis say, hey, look, guys, we had a right to stop them, and any information that we gathered was given freely because it was a casual encounter. The Indiana Supreme Court then quickly struck that argument down. They even gave, I think this is pretty funny. They gave him the benefit of the doubt. They say, assuming for the sake of argument, even if it started out as a casual encounter and Pinner was free to disregard the questions and walk away, that they say that the encounter quickly shifted from a supposed consensual encounter to an investigatory stop. And how they kind of define this is there's another court case, Clark, that goes into when a casual encounter turns into an actual detention, and the reference that obviously in this court case, Clark, that the casual encounter turned into a detention because the officer ordered the men in that court case to sit down on the floor and limit their ability to move. And in this court case, Pinner v. State, when the officers approached him in the movie theater, he was sitting on a bench facing a wall, and two officers kind of flanked all of his escape routes. And because of that, and the way that that court case started, or the police encounter started, the justices here say that makes it not a consensual encounter because he had no way to freely leave if he chose to do so. Now remember, guys, in this court case, the police are saying that they had reasonable suspicion to stop Pinner in this case because he had a firearm on him, and as Terry v. Ohio says, you can stop an individual briefly to stop and frisk them if you have reasonable suspicion that a crime is about to take place. Court here says that, recognizing that we have a right to keep and bear arms, that every state permits the exercise of this constitutional right under certain prescribed circumstances. Some jurisdictions, for instance, have found that where an individual is reported as having visibly displayed a firearm in public, contrary to state law, the requirement that police have reasonable suspicion that criminal activity is satisfied. So in some jurisdictions, if you bend over in your gun shows in public, that would satisfy that requirement for a Terry stop. But the court goes on to say that in instances whereas in this jurisdiction, meaning Indiana, a possession of a weapon is not per se illegal, and that states and jurisdictions like Indiana are reluctant to permit a firearms or weapons exception to the constitutional limitations already imposed by Terry. So here the court kind of dispels that myth, saying that, because in the state of Indiana, owning a weapon and having one is not in and of itself illegal, that just because you have a gun on your person does not by itself give the police enough probable cause or enough suspicion to justify a Terry stop to check for things like a license. They even go a step further in comparing their decision to the United States Supreme Court, Florida v. JL. I would encourage everybody to look up this court case as well. This is obviously a United States Supreme Court case, which had applied nationwide as opposed to this court case, Pinner v. State, that only applies to Indiana. But in Florida JL, they say that there was a man at a bus stop with a gun, and there was an anonymous tip saying that he had a gun, and the police came, searched him, and arrested him. And even in that court case, the court declared then that the question presented in this case is whether an anonymous tip that a person is carrying a gun is, without more, sufficient to justify a police officer's stop and frisk of that person. And the Supreme Court case in that ruling, Florida v. JL, ruled that it was not enough. They even go on to explain that, inserting an automatic firearms exception to our established reliability analysis would prove too far. Such an exception would enable any person seeking to harass another to set in motion an intrusive, embarrassing police search of the targeted person simply by placing an anonymous call falsely reporting that the target's unlawful carriage of a gun. The next step that the state took was that they said they had reasonable suspicion to stop and question Pinner because he acted nervous during the encounter. And the fact that he acted nervous constituted that he was rocking back and forth and wringing one's hands together in a nervous behavior. Court said that there is no crime in rocking back and forth and wringing one's hands together. And it goes on to explain that Officer Palmer did not find these actions to suggest anything more than, they quoted him as saying, maybe nervous, in his experience, just, uneasy with the question, maybe not telling the truth. They said that nervousness is of limited significance when determining reasonable suspicion, and they quote a few court cases here to back that up. Finger v. State, which is the Indiana court case, United States versus Salzano, if I'm pronouncing that right, which is a United States Supreme Court case applying to the nation, and then State versus Lee, which is another Indiana court case applying just to the state of Indiana. State versus Lee, for example, they decided that nervousness as a basis for reasonable suspicion must be treated with caution, because it is common knowledge that most citizens, whether innocent or guilty, when confronted by a law enforcement officer who asks them potentially incriminating questions, are likely to exhibit some signs of nervousness. And then finally, guys, the crux of the entire court case is right here. Says that we also disagree with the state that the officers were permitted under the Fourth Amendment to briefly detain the defendant to ascertain the legality of the weapon and dispel any suspected criminal activity. And they go on to say that the United States Supreme Court case has declared that, and the court case here is Delaware v. Prowse, that pulling motorists over on the road at random to check for to see if they had a valid driver's license was unconstitutional underneath the Fourth Amendment. That in order to stop a motorist, they had to have committed some type of infraction. It says here that holding that such exception in those situations in which there is at least articulable and reasonable suspicion that a motorist is unlicensed, or that an automobile is not registered, or that either the vehicle or an occupant is otherwise subject to seizure for violation of law, stopping an automobile and detaining the driver in order to check his driver's license and the registration of that automobile are unreasonable underneath the Fourth Amendment. They go on to say that in like fashion, we decline to endorse such behavior to ensure compliance with Indiana's gun licensing laws. This is precisely the type of weapons or firearm exception that other jurisdictions refuse to employ and the United States Supreme Court expressly disapproved of. Even go a step further in saying that where the individual is subject to unfettered government intrusion every time he exercises his right to bear arms, the security guaranteed by the Fourth Amendment will be seriously circumcised. So guys, this whole section right here is the entire crux of the court case and the reason why we have a solid chance in the state of Indiana of passing constitutional carry in the state. If people will get serious about it, call up your representatives, write them letters, reference this court case, and push the issue on getting constitutional carry passed in the state of Indiana, because as this court case determined, again, Indiana Supreme Court case, highest court in the state of Indiana, they said that you cannot stop an individual just because he's carrying a gun in order to check and see if he had a valid permit to carry a license. That in order for you to stop an individual and conduct a Terry stop and stop and frisk or detain and question him, if he's carrying a gun, it has to be for something more. He had to have been suspected of committing some crime that arose to the officer being able to stop and identify that person and check his license. That just seeing a gun on his person does not meet that qualification. That they have to have something more before they stop you and ask to see your license to carry a handgun. Right here, guys, in the conclusion, it says, upon de novo review, we conclude the evidence was obtained in violation of the Fourth Amendment, and thus the trial court erred in denying the defendant's motion to suppress. We therefore reverse the judgment and the trial court and remand this cause for further proceedings. And then in this case, a attorney by the name of Guy Relford, if I'm pronouncing that correct, is an Indiana attorney specializing in Second Amendment cases. He argued that Penner v. Indiana bolsters the case for doing away with the permit requirement altogether. That, as a result, law-abiding Indiana residents should not have to pay a fee to the state and undergo a separate background check to prove that they are eligible to exercise a constitutionally protected right. Apparently some law enforcement officials, including the Indiana Sheriff's Association, have argued that the removal of Indiana's handgun licensing requirement would inhibit police officers' ability to investigate the legality of persons' possession of a gun. Again, it's your right to own and bear guns. It is in the Second Amendment, which the only thing that the Second Amendment does is recognize a pre-existing right before governments were ever instituted. In the words of the ISA, constitutional carry would negatively impact efforts to investigate individuals and determine whether or not they are armed or not. They have no right to do so. Apparently, the Indiana Sheriff's Association need to do a little bit more homework on what their role is, and they need to do a little bit better, in my opinion, on upholding and defending the Constitution like they swore that they would do when they were hired onto the police force, to begin with. And the article goes on to say that, however, this argument has now totally evaporated as the Supreme Court has ruled unequivocally that police officers may not investigate individuals by detaining them for questioning or conducting a stop and frisk based only on a report that a person is in possession of a firearm. Well, hey guys, that's it. That's all I've got for you today. As always, leave a comment in the description box below. Let me know what you thought of this video. Hit the subscribe button and the little bell icon so you're notified every time I make a new video, and share the video with as many people as possible because I am still trying to become YouTube famous. But anyways, guys, that's all I have for you today. And remember that your freedoms and liberties are never more than a generation away from extinction. Let's get it cracking.